Oh, I just saw the meeting is being recorded. uh, it's important to focus on what your client is as a plaintiff suffering from so that you can paint a picture to the judge that is a compelling picture that would give the judge good reason to find in your favor. Um, I can just provide one example involving a case where an elderly adult who had shall we call it a girlfriend who he was living with, was taking advantage of him. He met her after she was knocking on doors in the neighborhood to do the census, and they ended up somehow sparking some type of relationship. The problem with the relationship is that uh, she ended up isolating his entire uh, group of children from his life in a short period of time. Also ended up uh, ingratiating herself into his finances. And that is something that we do see, unfortunately, all too often. Um, and and these are things that people don't usually report. It's very rare that a neighbor will see someone move in and say, "Oh, this is fishy. I need to call the cops." It's also very rare that a family member will take drastic action immediately. It's usually after there's a lot of damage done that us lawyers get the phone call, and it's a sad reality, but that is what tends to happen. Um, just to go over some of what the criterion is for abuse of an elder when dealing with terms such as abandonment. That can be found, and all of these terms can be found under the Welfare and Institutions Code, um, section 15610.05. And abandonment essentially is quite self-explanatory. It involves the desertion or willful forsaking of an elder or a dependent adult by anyone having care or custody of that person under circumstances in which a reasonable person would continue to provide care and custody. So, abandonment doesn't just mean that you leave the house with an elder all alone who otherwise can't provide for their activities of daily living. It can also mean living in the same house as an elder and not providing for the actual proper care or custody of that elder by willfully forsaking that elder. In other words, ignoring that elder. So there is a broad possibility of using that cause of action to support a claim for elder abuse beyond just what you would normally think is a person hopping in a taxi and leaving the state. Um, these are things that through time and practice, people begin to see. You can see an elder who over time has terrible teeth that before they did not have problems with their teeth, or are malnourished because they are essentially left alone, even though they may have a child or caregiver who is residing in the same house. So that is something just to be aware of. I mean, sometimes we have a little bit more creativity than rigidity in our claims as counsel for plaintiffs, but that's something just to be aware of in regards to your development and or your practice area expanding to include elder abuse. Um, Going to abduction, that can be found under Welfare and Institutions Code section 15610.06, and that involves removal from the state of California and the restraint from returning to this state, or excuse me, and involving any elder or dependent adult who does not have the capacity to consent to the removal from this state. I've been involved in cases both on the, you could say, plaintiff side or petitioner side, as well as the respondent side, where a loved one is taken to another state, and that loved one likely does not have the capacity to consent to that move. And that alone can be a claim that would be supported for an abduction claim of elder abuse. A lot of people say, well, that's my husband, and I can take my husband anywhere I want to go. Or that's my dad, and I can do whatever I need to do to protect my dad. The reality is it's a little more complicated than that. You have to have legal authority. And if you don't have legal authority and you're making these types of decisions on behalf of an individual without going through the proper steps and procedures, such as having a power of attorney, having a conservatorship, having the consent and agreement of all family members, then you can expose yourself to potential liability. So these are things that a lot of people in day-to-day life feel like, you know what, I will rather deal with it after the fact. This is my family member. But of course, by the time we get the phone call, we have to advise them of the risks of everything that they have done and or that their family member has done and the consequences. So abduction, that's a big one. Uh, that is also a crime, and Jill Henderson, who has a wealth of knowledge, can shed more light in regards to matters involving abduction should the topic arise. Um, Something to keep in mind also in regards to elder abuse, in regards to pleading elder abuse with the courts that we have, as I had stated before, we now have 2 probate judges. Um, Elder abuse is a civil cause of action. So when filing an elder abuse complaint, that would generally be filed in a civil court. A lot of elder law practitioners like the familiar confines of the probate court. Our court is generally pretty liberal in allowing elder abuse complaints to also be filed in the probate court. But I would advise caution to any practitioner who does not have what we term a hybrid complaint that also has an element of a probate form of relief, such as what is statutory under the probate code, specifically probate code section 850 to 859, when an elder or a conservatee has property taken from them that needs to be returned, or under a trust law statute such as 17200, or under a probate estate statute such as in the 11,000s. In other words, if you can combine both the probate causes of action that are statutory under the probate code with a civil cause of action under the Welfare and Institutions Code, I think you would have a more solid basis to proceed in a probate court instead of proceeding in a civil court. And you have that option many times to decide where you want to file that type of claim. The other thing in regards to elder abuse causes of action and elder abuse lawsuits is the right to a jury trial. So that is something that in the probate world, under the probate code, there is no right to a jury trial, generally speaking, for our probate matters. So when you are looking into filing an elder abuse lawsuit, an elder abuse complaint can get you a jury trial of your peers. And if you are in Contra Costa, you would have a perhaps better opportunity to have more peers who are elderly, given the demographics on that jury than a situation where there is a jury in another county. So those are all things to keep in mind when pursuing relief for elder abuse and when identifying potential causes of action involving elders who are taken advantage of. Um, One thing to keep in mind in regards to the definitions, a dependent adult, unlike an elder, an elder is someone who is essentially over the age of 65. A dependent adult under Welfare and Institutions Code section 15610.23 is anyone who is between the ages of 18 and 64, who resides in the state and has a physical or mental limitation that restricts his or her ability to carry out what are deemed normal activities, which is a very broad term, or to protect that person's rights, including but not limited to persons who have physical or developmental disabilities or whose physical or mental abilities have diminished because of age. So as you read that statute, it is pretty evident right away that there is a very broad potential application for what can be considered a dependent adult. So, I could make jokes, but the reality here is that this is a serious situation where you have people who are not able to take care of themselves, who are preyed on by people who see an opportunity. And when you see that as a practitioner or you hear that on the phone from a potential client, those are things to key on. So hopefully what can be taken away from today's presentation is some of these identifiers. When you hear, see, or read about claims or potential claims, you can say, I have now spotted the issue, and this is potentially an elder abuse case, or this is a potential dependent adult abuse case. So don't just foreclose your lawsuit to someone who is 65 or older being the selected pool. You may have someone who is 63 years old and who is got diminished or who has diminished mental capacity, who is beginning to have certain reduced cognitive abilities. And that person would, by statute, fall under the category of a dependent adult. And a lot of the times, practitioners ignore that and just focus on the age. So I think that's something key to take away today. In regards to some of the other definitions, as I was talking about elder, that can be found under Welfare and Institutions Code 15610.27. I won't repeat that in regards to the age requirement. Financial abuse of an elder occurs under certain circumstances by statute. And under probate code, under Welfare and Institutions Code section 15610.30, financial abuse occurs when a person takes, secretes, appropriates, obtains, or retains real or personal property of an elder or dependent adult for a wrongful use or with the intent to defraud or both. And Jill Henderson, who is a criminal lawyer, will talk about intent and mens rea, which takes us back to law school. But that is, again, a key element in regards to claims of financial abuse. All that needs to be shown for someone to allege financial abuse is an actual taking or hiding or misappropriation of property for a wrongful use or with the intent to defraud. And so that is something where if a person who is a caregiver, who is supposed to provide for the elder or the dependent adult, and instead is now doing things that show an intent to take property or show an intent to trick a person that you would say is not a standard professional way of handling business, that would fall into the category of financial abuse. So again, I'm trying to focus on some of the more nuanced potential claims that you may not be aware of on the surface level, and that would help protect elders or dependent adults from improper acts or behaviors by those who are supposed to provide care for them. One of the second, or I should say the second criterion of financial abuse involves someone who assists in taking, secreting, appropriating, obtaining, or retaining real or personal property of an elder or dependent adult, or a wrongful use, or with the intent to defraud, or both. So again, a scam artist, someone who is a straw figure, someone who is a setup person for the ultimate criminal or the ultimate perpetrator, that person could be held liable for financial abuse even if they don't take a dollar, just by way of trying to trick the elder or dependent adult, or trying to gain access to that elder or dependent adult's property. And harping on property for a second, that is not just money and housing. You could potentially make the argument that paperwork, records, emails, and other items that are not necessarily tangible are also considered personal property. So if an individual is assisting another in obtaining that information, or is doing something with the intent to trick a person, which is my layperson's way of saying defraud, then that person could be held liable for financial abuse. Why is that significant? It is, as Carolyn Cain will later explain, very important because there are mandatory attorney fee awards if you are successful in prosecuting an elder abuse action. And those can be tremendous. The third item in regards to what can be considered financial abuse is when a person or an entity takes, secretes, appropriates, obtains, or retains, or assists in taking, secreting, appropriating, obtaining, or retaining real or personal property of an elder or dependent adult by undue influence, as defined in section 15610.70. And for those of us who practice regularly in the probate arena, one of the buzzwords that attorneys really like to talk about is undue influence. And undue influence is something that case law has stated can rarely be seen at the time that it's happening. It's not something that happens in the open. It often happens behind closed doors. And the cases, including the state of Sarabia, Lentz v. Lentz, and numerous other cases, including Keating v. Keating, that has recently come out on appeal, show that for undue influence to occur, it can happen without any obvious signs at the time that it happens. What does that mean? That means that oftentimes as practitioners, we see people come to us with documents that are 5 years old, 10 years old, 15 years old. And those documents have changes. Those documents have changes that redefine the landscaping of an individual who has lived a pattern of behavior their entire life. Why is that significant? Because most of these people who are elders grew up in a time when they didn't do things without patient consideration and talking to their family and sharing things in a very generous way with those closest to them. So when late in life changes happen, when those people do not share that information with those closest to them for whatever reason, and or drastic changes are happening that go across what is considered logic by most family members as to what were habitual behaviors by the individual, that suggests undue influence by someone or some entity. Doesn't always mean that it happens, but again, this is one of the things that in the elder law arena, people tend to label as potential or actual undue influence. And undue influence is defined as excessive persuasion that causes another person to act or refrain from acting by overcoming that person's free will, and that results in inequity. So what that means is if I unduly influence my dad to play the lottery and he spends $1 and he wins $1 million, I did not unduly influence him because he just made $1 million. So he may have a claim against me for $1 and he probably would win on that. But in regards to an inequitable result, the idea is that what is being done would create harm. So if you have an only child situation or you have a 2-child situation, and the result with the only child is that the estate planning has everything going to the only child and there was no prior estate planning, that would not be an inequitable result. If you have a situation where there are 2 children and the estate planning is created for the first time and it provides for the 2 children to get everything equally, that would not be an inequitable result if what would have resulted was the matter would have gone through probate. So there is a very key distinction that the legislature put in there in regards to an inequitable result to qualify what would be otherwise considered undue influence. Case law has also made clear that when you have a situation involving excessive persuasion, that it is akin to destruction of a person's free will. It's not just, batting one's eyes and saying, I would really like a nice car, or I could really use a new diamond ring or something like that. That's not excessive persuasion. Excessive persuasion is such that it's nearly akin to coercion. And like I said before, you're talking about the hijacking, as case law has stated, of a person's free will. So that gives a graphic example of just how severe undue influence really is. It's really not influence. It's more puppeteering. It's more pulling strings. It's less of a suggestive nature. And when considering what undue influence would be, there are various factors to consider. The vulnerability of the victim, which can include whether or not the person has a type of mental impairment, in this case with statute, incapacity, illness, disability, injury, age, education, emotional distress, isolation, or dependency, and whether the influencer knew or should have known of the alleged victim's vulnerability. So this is a situation where, going back to my example of it has to be more than just suggestive. If you have a person who is known to be unable to control themselves and unable to resist a certain person or a certain type of stimulus, and someone who knows that uses that to enrich themselves at the expense of the elder or a dependent adult, then that would be considered undue influence. So that is something where when you add those elements together, the chemical reaction now becomes undue influence. Whereas before, in a vacuum, without that element, it wouldn't be. The second possibility involves the influencer's apparent authority. Again, a lot of the abuse we see involves family members, involves people in a power position, sometimes even lawyers. There are cases where lawyers take clients who lack capacity to a certain uh, place in regards to either trust administrations, in regards to estate planning, in regards to lawsuits, where they are essentially now running the show and the elder or dependent adult has no say. And those are situations that the statute, that the legislature has codified in statute that include apparent authority, such as a fiduciary, which a lawyer is, as well as bankers, a family member, a care provider, a healthcare professional, legal professional, spiritual advisor, expert, or other qualification. So again, you can see how broad this statute is, how it's designed to protect those who cannot protect themselves, and how those who are victimized by others have avenues for relief. Now, the third item involves actions or tactics used by the influencer. And this is a situation that can get pretty ugly when a person controls the necessaries of another's life, manipulates medications or interactions with family members. Those are things that can lead to the abuse of an elder or an inequitable result as well. What you'll see also is now the use of affection, intimidation, or coercion. So going back to the vacuum sealed analysis, now you move in with a loved one or girlfriend or boyfriend scenario, and they say things like, you know what? I don't think I can be your boyfriend or girlfriend if you don't take care of me. I don't think, I can live on less than $5,000 or $10,000 a month. And that had never been the case before. In other words, the result before would be inequitable because that influencer had never been given that amount before. And now they're saying that they will withhold affection and or are providing a form of emotional blackmail to try to get what they need. A lot of times this can even be done in a naive, unknowing way by the abuser. For example, how am I supposed to live if I'm taking care of you? You need to give me something. I need something. How am I supposed to, survive if I have to be here all the time and I quit my job? So again, the idea here is to allow the elder or dependent adult counsel and an opportunity for a fair result if what is being done is providing that caregiver fair compensation or a reasonable and equitable compensation package that would make sense. If what's being provided is not an equitable result, and instead it's a huge windfall for doing very little, then that would be considered elder abuse and undue influence. Now, the key thing in regards to undue influence is that just having an inequitable result alone is not enough. So if we have a scenario where you have a non-relative who is a significant other, and they are now being provided for in a will or a trust where before they were not, and they only recently met someone, that's a very dicey, hard to vacuum seal and call it anything other than a case-by-case analysis. These are very case-by-case, like a snowflake. It's hard to know if a person who is with another one for 6 months, 6 years, or 60 years is receiving an inequitable result without actual evidence or something in support beyond just the inequitable result. So that's one of the things that most people tend to ignore, but those are important. I'm running out of time. I'm pretty much done with my part of the presentation. I'm going to go ahead and take a time out to give the microphone to Jill Henderson now. Thank you, everyone.
Thank you, Costa. Hello, did I successfully share my screen? Okay, I'm going to, okay. Thank you, and thank you all for having me. I am an expert in criminal law, definitely not civil. So I think I could dovetail nicely on what Costa just taught you all, because sometimes we can define what is civil or what is criminal by taking a look at the other animal and contrasting. So I browse through the participant list. Hello, Mr. Bray. I know some of you have heard me speak before. I hope I didn't recycle too many of my PowerPoint slides. But I have been doing elder abuse for, I think, maybe 6 or 7 years now. And I head up the unit now. I don't carry an active caseload anymore, sadly. I really enjoyed it. And I also head up the domestic violence unit. So it's a very busy job indeed. So let me go ahead and share with you my experiences. So to echo on what Costa just said about elder abuse, I took out my slides real quick about the exploding age population, but I just want to emphasize the basics that elder abuse is a crime, because he just read you the civil definitions. The penal code reads the exact same way. It is a crime and it goes unpunished. The vast majority of it is undetected. It affects both urban and rural areas, all socioeconomic groups. It's escalating. And my favorite bullet point on this slide is a lot of elder abuse is where domestic violence was 30 years ago. I always make it a point to emphasize that, because what does that mean? And when you think of domestic violence 30 years ago, and my goodness, I think it was about 30 years ago when I was in law school, and to get units, to do anything other than going to class to get units, I worked for BWA, Battered Women's Alternatives. It is now known as STAND. And I would help battered women prepare declarations, and I would take them to the court and I would get their restraining orders. And the culture back then with domestic violence was much, much different than what we see today. If a police officer came to your house and you answered the door with a black eye and said, "Everything's good here, officer, I just hit myself in the face with a hairbrush," the officer would say, "Peace out, it's your problem, goodbye, not my job." People in domestic violence situations were encouraged to resolve it with their church. It was regarded as a family issue. And we all know what happened with domestic violence. It started ending with too many dead victims. And so we completely reformed how we look at domestic violence. And I would submit to you that in the penal code, I'm just leaning down here, that in this whole big penal code, that the domestic violence statutes are unique in how many times you see the word shall appear. The police shall make an arrest. The emergency bail schedule right now due to COVID, it's not released for domestic violence. Domestic violence, we all know, can be fatal, and it's riddled with shalls. Sadly, elder abuse has not reached that area within the law. I'm not seeing it being treated in the way that it should. This is a statement, I think it was by a vice president. I don't, the slide doesn't have the quote on it, but we are measured as a community by how we care for our very young, the elderly, and the defenseless. And I frequently put this in my sentencing memorandums when I'm asking that an elder abuser go to prison, because it is despicable when it is absolutely our most vulnerable being abused. So it is growing. There's no cure for dementia. Our victims aren't reporting. The third fastest growth job is in home care. So I hope Francesca is listening. And thank you, Francesca. We just met for your LinkedIn request. I forgot my password. So if anybody finds me on LinkedIn, I'm not ignoring you. I just don't know how to log in. So this growth, I got to tell you, I read rap sheets every day of my life, and right in between some, robbery convictions and what have you, I will see elder care in-home applicant. And yeah, so when you're not dealing with professional organizations, you just pray that people aren't getting hired off Craigslist, but you can imagine the high temptation because of the cost. And the situation actually gets worse in good economics because good people are hard to find and labor is expensive. The dynamic of elder abuse also makes this picture even more grim. The fear factor, it's changing a little bit, but my grandma never called the police in her 99 years of life. You just didn't do that if you weren't bleeding or the house wasn't on fire. Lawyers were something for the wealthy. Lawyers are fancy people. I'm sure my grandmother never hired a lawyer in her lifetime. Fear of the suspect, shame and embarrassment. I've seen some lotto scams where there is no convincing this mister that he's not going to win the lottery. He hasn't really won the lottery. I think there's a whole movie on that, right? Where the victims still have their faculties. They don't appear demented, but they will pursue, they've kind of lost a little bit of that filter, and no matter how ridiculous their claim seems, they will pursue this scam till the end. They won't back off. Elderly people are comfortable and deserve to live out the rest of their days in peace. They don't want to shake the status quo when they're 90. They don't feel like moving or divorcing, and they want their independence. So it is extremely troublesome dynamic that needs to be recognized. And I preface that with the prosecution because I'm sure the burning question is the same one I always get. Well, then why aren't you prosecuting more people? And so let me tell you. So Penal Code Section 368A is a declaration. The actual Penal Code statutes are codified in Penal Code Section 368B. That starts with force likely to cause great bodily injury, the felony, elder abuse. But 368 is this brilliant declaration by our legislature about how important elder abuse is and that they are deserving of special consideration and protection. It acknowledges that they may be confused, on medication, or impaired, and they're not able to protect themselves. So what I want to know from the legislature is, what does that get me? And the answer is, it gets me absolutely nothing. That they recognize that, thank you very much. It's a beautiful declaration, but it doesn't give me a hearsay exception. It does nothing to help me with the Sixth Amendment. It doesn't do anything to lower my burdens of proof. And I think I have the slide in here, I'm not sure because of the nature of this audience, but it also doesn't give me any sentencing enhancements. Pretty much when I prosecute elder abuse, all it does is give me an additional element. I have to prove that the perpetrator knew the person was elderly or dependent. So thanks. That's the background that we're dealing with. So our mission statement is to seek justice. I frequently, sometimes victims will call me and say, hey, why don't you file charges on my cases because it's too little, it was only $5,000. And my answer is absolutely not. We don't have a dollar amount. We never tell victims that their case is too insignificant, or the dollar amount is too minimal. I think the best I ever did was a $5,000 bad check case, a first time offense, and an adult daughter of her victim forged her mom's name and used her mom's ID. I think the defendant was 50 and the mom was like 90, and the credit union didn't make that out. But anyway, it was $5,000. I went to preliminary hearing. It was the defendant's first offense, and bless Judge Kennedy, he said, yeah, that's a felony. So we really pushed the limit, and $5,000 made the felony threshold in that case. Most of our judges are pretty on board with elder abuse and understand the importance of it. Having said that, what am I limited by? I like to think of it in terms of marijuana. So I can stealing $5 is technically a crime. I can bring a criminal action, a theft case, a misdemeanor theft for stealing $5. So why don't I? Well, that's because I can only file a case where I am assured or reasonably believe that all 12 jurors will vote unanimously to convict. So on some of these de minimis amounts or de minimis behavior with no injuries, like a slap, a spit, technically they're crimes, but would a jury convict or would they nullify? And the way I look at it as on some of those cases, they would nullify. Just like they would for, I don't know, before marijuana was legalized, a marijuana cigarette in an 18-year-old's locker at school. I mean, come on, there's just no interest in it. The public won't support some prosecutions. You have to keep in mind that it doesn't matter whether we're dealing with a murder or $100 petty theft or a single slap to the face that didn't even leave a red mark. We still have to bring an entire jury panel, pick a jury, go through peremptory challenges, and have a full-blown jury trial, jury instructions. The process is the same. So speaking of file charges, how does it work? There I am in the middle, and these are all the agencies in Contra Costa County that take criminal reports and then bring them to me to review for charges. Some agencies investigate cases better than others, but we offer ongoing training, and we are seeing very high quality investigations. I would give a shout out to probably Moraga and Orinda in particular, where they see a lot of financial fraud, and they really partner with us in reaching out and doing a good job on those cases. Orinda just recently had one that was hundreds of thousands of dollars, if not even in $1 million, and they were a bit overwhelmed with it. So we got the federal government interested in it, and federal tax evasion and other federal charges have been filed, and we feel like that is the best outcome for that case. Which brings me to a point. The fiduciary who was involved in that case, who discovered the fraud, was very upset that we were not filing tandem state charges. So what I told him was that it's things are never set in stone. A lot of times I will decline charges on a case, and it's still in our system that if another case pops up, you know, 2 punches are better than 1 in terms of proof, right? I can always undecline charges and file it if I'm within the statute. So I told this fiduciary, thank you for your concern. Thank you for looking out for this victim. Why do you want state charges when the federal sentencing, the federal proof, everything is in prosecution's favor federally? And he said, well, the only assets left are some vehicles, and I want to get a state charge so that probation would seize the cars. No. Our probation does not collect assets. We don't do asset seizures. We just don't. We'll have criminal restitution ordered, but without collection, it's just a piece of paper. Having said that, crazy things can happen, right? I like to tell my favorite story about financial fraud. It was People versus Rodawig. It was a criminal prosecution. Our very dear, sweet victim, Bunny, I think she was 92 and legally blind. So her wealthy family hired her a caretaker, the sweetest young gal you ever did see, from St. Mary's College. I mean, the picture of a person who could never steal. And she stole. But what thieves do is they do tester charges. If you've ever had your credit card taken, they do like $1 and then a few dollars and like, hey, it works. And then they get bigger and bigger and bigger. So they get as much as they can before the riskier purchases, so the asset isn't shut down. So same thing in this case. It started out a few $100,000 and it went up from there. So at some point, Bunny called her adult daughter and said, I'm broke. And the family's like, what? You had like $200,000 and your cost of living is like zero. So it wasn't too hard to find out who stole the money. The defendant had stolen Bunny's checkbook and was writing checks to herself and then depositing them in her own account with Wells Fargo, which was also the victim's bank. So I had my investigator freeze the assets. The defendant had stolen so much money so fast that she had $54,000 still sitting in her account. Then we told Wells Fargo, hey, you have to refund fraud, but they'll only do the first 30 days. And so they gave the victim back like $7,000. Like I said, the first 30 days was not very much money. I wish I could have picked the last 30 days, but that's all they would do. The banks are totally unwilling to accept any liability for their part on these ridiculously not even close signatures, not to mention the outrageous pattern that popped up out of nowhere. I don't know what they thought Bunny was buying, but come on. But I put extreme pressure on Wells Fargo to no avail. The victims hired a civil attorney to protect their civil interests, and he settled with Wells Fargo. And I later learned that it was for $54,000. So I will wrap up the story because there's a lot of material to cover, but I threw quite a fit when the judge decided to release the defendant on her own recognizance after the preliminary hearing based on the dollar amount. But she did have no criminal history, and she truly did not pose a physical danger to society. I was just worried about her to continue to steal. So the judge imposed these probation orders on the defendant that she get a job, that she somehow get a job, but disclose to her employer everything she stole and everything she did. And lo and behold, she did. She was released from custody. She got a job at Taco Bell. And then the judge made her set up an account where her paychecks were direct deposited, but I had control over the account. So I had all of her paychecks. So I just dragged the case out for literally years. And I think we ended up getting like $32,000 from the Taco Bell earnings. So I was wrong. It was a good thing that the judge OR'd her, but I've never heard of such a thing in my 24 years of doing this. So in the end, it was then discovered that the $54,000 that Wells Fargo had agreed to give the victim, they were planning on giving the victim her own money in the defendant's bank account because they didn't know that I had already seized that money. So Bunny got $7,000 from the initial Wells Fargo. She got the $54,000 that I seized. She got a new $54,000 from Wells Fargo and $32,000 from the Taco Bell out of $200,000. So not too bleak of an outcome, since I think we all know, no matter where you are in your careers, that usually once the money is gone, it is gone. So what am I seeing? That was a financial abuse case. One of my probably one of my favorites, simply because it wasn't great. We got a prosecution. What does that do for the victim? We're about 50-50 in terms of physical and financial, what we see. 90% of the physical is a son on the parent. We see a lot of mental illness. It's very problematic. 90% of the financial is by a trusted person. I just told you a story of an example of that. The trusted people have access to the money. An elderly person walking down the street or loading their car from Safeway is just as vulnerable as anybody else. I mean, maybe they're targeted because they're weaker, they won't fight back on a purse snatch, but overall, what we're talking about is people who you trust. I don't have any prosecution for strangers, mainly because I don't take them in my unit. I do positions of trust, but even in special operations, once the money's been sent to the Prince of Nigeria, there are federal agencies who investigate it, but the success of that is not very good, and they will prosecute it federally, postal fraud, that type of thing. So I'm frequently asked to talk about what financial scams do you see? What are the criminal financial scams? And you know them. I teach about Scam Stoppers, law enforcement, the Rotary Club Kaiser. We try to tell banks, hey, don't, come on, compare signatures, look at bad habits. And if you feel like something's wrong, if somebody's at the bank with an elderly woman with their hand on her neck and she suddenly needs $75,000 for new tires, you don't have to give them the money. Take a time out. Come on. So education, I think, is the answer to a lot of the stranger theft. So that's not what keeps me up at night. It's protecting our seniors from the people that they trust and love. And that's a really sad message to give to our seniors. Don't trust your daughter. Don't trust your caretaker. But those are the ones who are stealing. The typical abuser profiles that middle-aged son living at home with a mom, divorced or single and unemployed, either mental health, some sort of codependency. And we really use multidisciplinary approaches to try to deal with this complex dynamic. I mentioned earlier that criminally we're codified at 368B for physical abuse. It's the same as any other, battery. 368B is the felony level, 368C is the misdemeanor level. We have a false imprisonment for elders under 360F. The false imprisonment for everybody else is 236, and the sentence is exactly the same. It doesn't get me anything. So yeah, the charges might sound fancy. Oh, elder abuse or false imprisonment of an elder. It's just false imprisonment. It's just battery with force likely. The theft offenses are codified in 368D and E. D's for caretakers and E is for non-caretakers. One would think that when you're violating a position of trust and you're the caretaker and you steal from the person you are charged to take care of, that perhaps we would treat that a little more severely, but we do not. To get to the felony level, there's a $950 requirement. And we can get CPOs issued quite easily. Those are criminal protective orders. I know in the civil arena that getting a temporary restraining order and then getting things served and then having orders after hearings and dealing with that can be quite a process. With our CPOs, once we file any case, I just fill out the CPO. I don't even do it. My clerk auto generates them. They're so routine for us. And then when the defendant is arraigned in court, he is automatically served by the judge with the CPO. So we're one and done. And then at the time of conviction, that CPO is converted to a different flavor CPO, protecting whoever we want for up to 10 years. I realize that when we need sticks, that I have a lot of sticks at my disposal, and it makes me happy to be able to protect seniors in appropriate cases when these sticks, and sometimes an older victim will call me and say, well, hey, he's my son. I don't. The most common call I get is, well, and the police hear it from day one, is, hey, yeah, he bashed me in my head with my own cane. I'm bleeding. I'll get stitched up. No big deal. Do you want him arrested? Do you want to press charges? No, I just want you, the government, the police, the DA, don't prosecute him. Just make him go back on his medications and make him go to therapy. Just fix him for me. And they're just completely baffled with this concept that the government doesn't have jurisdiction over sovereign citizens to make them do stuff. So if I have any control over getting money for Bunny or getting this woman's kid on his medications for both of their welfares, I have to file a criminal action. I can't just do things. So sometimes I can get victims more on board by pointing that out, that I would love to do that, but I can't just, I can't do that. So here's a case on undue influence. Undue influence is purely a civil beast. So that's Costa and Carolyn's domain. I just put that site up if you want to read more about that. Don't ask me to speak on it because it's not my thing. We just don't do it. It's not a crime. That's civil. And there's also People versus Brock talking about attorneys as fiduciaries. I found those two cases, two of the more helpful ones. So that turns me to the issue of autonomy. I think, and some of the people here have heard me speak before at other events, and a very common question I get is, why doesn't APS save these people who are being neglected and abused? Why? We report to APS and then nothing happens. So it took me a minute, but I think I figured it out. If you compare and contrast what APS, the Adult Protective Service branch of your government, does, let's contrast that with CFS, Children and Family Services. It used to be called CPS. What's the difference? So if a teacher or a parent, if there's elder abuse suspected, they go into the home and they take the child because the child is a minor. When APS comes into a home, no matter how bad the abuse is, and we've seen it all, decubitus ulcers, feces, not dressed, freezing, starving, no medication, the worst neglect, actual death they've seen, they can't do anything. They can't do anything. APS is 100% bound by the notion of autonomy. They can't say, this is absurd, she's going to die, we are taking her. They can't do it, so they don't. So what we're trying to do is get APS to call the police, because they will. The police have better tools for this situation at their disposal. They will 5150 the victim if they have to, or arrest the suspect. They will do something rather than leave a helpless person in grave danger. So that's what's going on there. As mandatory reporters, you still report to APS, and APS has a whole array of amazing social workers. They can, if she's not getting enough food, they'll get her signed up with Meals on Wheels, whatever the issue is. If they need in-home support, they'll do that. If they need their Medicare worked out, they can do all of that. I'm not discouraging anybody from APS and the social services that they offer. I mainly urge you to differentiate between social services and a crime. When you have a crime, when you see a crime, you call the police. APS workers are not forensic collectors. They don't know how to document the decubitus ulcers and the status of the house. They can't open the cabinets and look at the medication bottles and see when they expired. They're not going to look in the toilet. The police know how to do an elder abuse, and they have been trained to do an elder abuse investigation much the way they would a child abuse investigation. Does the child have food, clothing, the basic necessities of life? So if you ever see physical, call the police, and they are the ones trained in taking that kind of reports. Yes, they might tell you on a financial, it's civil, and they, I hope, are most likely right. They can get it wrong sometimes, we all can, but they will usually call me if they have a question. Having said that, it is extremely problematic when we have a late report by a non-victim. So jurors would just not be happy to hear that in a family financial feud where both sides have lawyers, it's nasty, the accusations are flying, and then I'm going to say, okay, Johnny's the culprit here, he was stealing, and Janie is the good sibling, she was entitled to the money, and so I'm going to file a charge on Johnny, and we're going to have a criminal trial, and the juror's going to sort this whole thing out and convict with proof beyond a reasonable doubt. And we know all of this because the lawyer for Janie called us up and said, hey, look at these historic records. That has like zero jury appeal. That is just an extremely poor mechanism for family messiness. It is not a good forum for that. So on cases that may seem glaringly obvious to you, I have to look at it through the eyes of a juror and the rules of the evidence code, and knowing how my bench typically rules, what evidence would actually be admitted, what would the defense likely be, and do I think I can get a conviction? So I appreciate your mercy in knowing that it is not that I don't care or I don't have enough resources. That is my limits of my ethical bounds. When we do sentence, remember the lady who's like, don't arrest my son, just make him get just fix him. And the good news is we don't just send people to prison when they have mental health issues or contributing factors. We have behavioral health court. We can order drug treatment. We can put them on probation. We can order restitution. And then when necessary, we can do jail, prison, and life imprisonment. So we do have an array of tools that you can tell victims when they're hesitant to report a crime because they're worried that all we're interested in doing is locking people up. It is not punitive in some cases. Another thing I want you all to be aware of is the FJC. We now, thank goodness, have the family justice centers. It's a one-stop stop for victims of elder abuse, domestic violence, human trafficking, sexual assault. We have one in Richmond, Concord, Antioch. They don't have to make an appointment. They don't have to go through red tape. They just show up and say, I need a restraining order, or I just discovered, I think my grandson stole money from me. What do I do? And the FJC will not turn them away. They will figure it out. They will figure it out. They have a lot of resources, very solid staff. They have an assigned navigator, and they will do it. In fact, I'm excited, Samantha, that perhaps I'll put you in contact with them to talk about some of that low bono work as part of your moderate means. They do have a lot of pro bono attorneys in there. So there might be an interesting connection that we could make. When I don't file charges and there's a gun in the house, the police have been trained on GVROs for law enforcement. That's a gun restraining order. So if I can't file charges for whatever reason, the police can still seize guns. So this is a slide I use in my law enforcement training of how to get a GVRO. But basically prevention is the key. I would like to not be reactive to domestic or elder abuse. I want to stop elder abuse. So that we're going to do questions and answers at the end. I think I have just a couple more minutes here, and I wanted to spend that time to be responsive to a couple of the topics that Costa told you that I would speak on. Thank you, Costa. So you talked a little bit about kidnapping, and obviously we have criminal kidnapping as well, right? If you take a body, I just filed one today. The victim was on the phone screaming 911. He's kidnapping me. He won't let me out of the car. That's kidnapping. You don't have to go across the state line or anything. It can sometimes be as little as 15 feet if someone's beating you up and drags you to an increased place of risk. So I file kidnappings all the time, but they're pretty egregious. It's with force or violence. It's against a person's will. In terms of intent and mens rea, I don't really know what that is for theft crimes. We all know what theft is. You know, when you see it, you take something that doesn't belong to you. We can't litigate in criminal court the issue of, well, I felt like it belonged to me. Some of the most common failures we see in caretaker thefts is that slippery slope where the victim says, hey, go to the store for me. Here's my ATM card or my debit card. Here's my code, and get yourself a little something. Well, the victim's interpretation of a little something and what the defendant or criminal does is obviously not okay, but it would be an impossible burden to meet. Those slippery slope cases are very aggravating. We just take it on a case by case basis. Every fact is unique. I will say that the definition of a dependent that I'm seeing in the criminal world is a little bit different, maybe in the civil world. I did a case where the victim had a dementia and the night pill nurse raped her. It wasn't forcible rape, but she was very far gone and did not have the capacity to consent. So the level of dementia, the whole trial was, he said she consented. So the entire trial was about proving that lack of capacity to consent. And sadly, there are no reported cases of rape of someone with dementia in California because it's just never discovered or reported. Very tragic. So let's say in that case, I prosecuted someone for rape. He was convicted. He went to prison. There's still a civil case there, you know, that I don't think, yeah. So sometimes we overlap. One quick last point is on the concept of care and custody. that is plain language, care and custody. So the seminal case on that is called People versus Oliver. It's a criminal case where a man and a woman who were total strangers hooked up at a bar, they were drunk, and they decided to go back to her place, Miss Oliver's place, to do more drugs. So when they get to her house, the victim says, I want to go, do you have a spoon? I want to go do heroin in your bathroom. So she says, sure, and gives him a spoon. He subsequently overdoses, and she sees him like frothing at the mouth and convulsing on the floor. So she leaves. And he wasn't dead yet. But then her daughter came home and said, hey, Mom, I'm having friends over and there's this like dude on the floor. So I think she came home and maybe like helped her daughter drag him out back where he died. I don't know at what point he died. But the issue in that case was, did this woman have a duty of care to the decedent? And in that case, the court said yes. She brought him home knowing he was intoxicated and helped him get even in an even more dangerous position, both by helping him do drugs and by taking him from the bar, where if he started to seize, the chances of a patron or a bartender seeking help would have been better off than isolating him in her home and then just leaving. So normally, if you're walking down the street on a Sunday afternoon and you see somebody bleeding out with arterial bleeding, you can choose as a citizen to walk past that person. You don't have to do a darn thing. There is no crime. But if you assume a duty of care by having custody or control over a person, and this person was not disabled, he was just a partier, she assumed an affirmative duty of care. And once he started seizing on the overdose, she had to call 911. She had to render aid. So she was held criminally liable in that case. So that case has a lot of applicability. I actually did a homicide where same thing, a girlfriend checked her brain damaged ex-boyfriend out of a group home where he was covering from a catastrophic brain injury. He had dog tags on. He was 42 wearing a pirate patch. He had a broken walkie-talkie that he played with as a cell phone. He was incapable of using a cell phone, extremely low functioning. And she got permission to take him to the movies and Taco Bell. And instead she took him to the Marais Motel in Pittsburgh. They did methamphetamine. She lost him and he was hit and killed by a car. So that's just straight civil liability. She had an affirmative duty of care and she was criminally negligent. Well, I just contradicted myself. Criminal negligence, where she violated that duty of care and she was convicted of the homicide for his death. So I am out of time. Luckily, this is recorded. I know I go very fast, so you can go back through. There will be questions and answers at the end, but I don't want to cut into Carolyn's time. I'm sure she has a lot more to say, jumping back to the civil arena. So thank you so much for your attention.
Hello. Oftentimes clients will come to you and they'll have a complaint or a concern that their mother's or their father's property has been taken from them as an elder or dependent adult. And oftentimes it comes to your attention, not only has property been taken, but there's ongoing abuse. There's physical abuse, there's harassment, there's whining and complaining about money, and you have to stop that. And so you can get an elder abuse restraining order for elder or dependent abuse. Now, Costa Demiris has already given you the definition of who is an elder and who is a dependent adult. But this is an extremely helpful tool because the elder, the dependent adult, they're vulnerable to the undue influence. And oftentimes what happens is you'll remove the perpetrator from the elder or dependent adult. And then there's this period where the elder wants to reconcile. And then the perpetrator acts out again. And then the elder is like, no, I really want the restraining order. And so you have to get the TRO, you have to get a restraining order to stop the abuse. And it's really important to know that there's a different standard of burden of proof for the elder abuse restraining order. It's by the preponderance of evidence, and the site is Bookout versus Nielsen. Welfare and Institution Code section 15657.03C talks about a reasonable burden of proof. But what does that mean? I think the book out case gives you better guidance. And then standing. Sometimes the elder person, because of medical issues, or they're in the beginning stages of dementia, or because it's a family member or close friend who's the perpetrator, they can be not such a good witness. So it's really important to know that an elder, the dependent adult, the conservator, a trustee, an attorney in fact, or a guardian ad litem, or some other person can be appointed by the court under Welfare and Institution Code section 15657.03A to seek the restraining order. I recently had a restraining order hearing, and my client firmly wanted the restraining order, but it would have been helpful in hindsight if I had had a guardian ad litem appointed, because she was susceptible to getting confused. We got the restraining order, but it might be helpful to have someone step in. Now, when you're getting the restraining order, you also might want to include the family member, household member, or conservator who's helping protect this person. Now, Jill talked about how the typical profile is the middle-aged son who's unemployed. I don't have statistics. I just know that it's often the son or the daughter or a grandson or a granddaughter, and they're very much manipulative. And when another family member steps in to protect the elder, that person becomes the target of the perpetrator's hatred because they've stopped the harassment, they've stopped the financial bleeding. And so you really need to consider, should you protect someone else who's also going to be abused by the perpetrator? Now, you have to also understand that you can call the police in some circumstances and ask for an emergency protective order. I've never had a case where the elder was physically abused and I needed an EPO. I usually have the cases where it's emotional abuse, it's screaming, it's yelling, it's harassment, it's a financial drain. Now, it's important to know that the CEB and other firms that sell the judicial counsel forms, but the CEB has specific section for you to fill out the elder abuse restraining order. So it makes it easy to understand what forms you need to fill out. And if you have any doubt, fill out more forms than what you actually need, just to be safe. And then when you're asking for the ex parte temporary restraining order and you're asking for the request for orders, be sure to ask for more orders than what you would actually. Be sure and ask for all of the orders that you need to protect your senior, your elderly person, because if they regularly attend church, the perpetrator is going to know that, and they're going to try and get at them in church outside of COVID. If they have an apartment house that they manage or they collect rents from, or a business, or if they have a beloved pet, you can include the pet in the restraining order. So go through all the boxes and check and ask for all the relief that you need to protect the seniors. Now, it's important to know that you cannot exclude the perpetrator from his or her own home. You have to show that the protected party has a colorable claim of right to live in that residence, that they have legal or equitable title. Now, recently I had a case where the senior, the elder the title to her home was taken, and I attached the deed from 1983 when she and her husband acquired title, and then the most recent deed where her son had a grant deed drafted where the son put himself on title and took the title away from his mother. But he claims that he was incapacitated, but he was also smart enough to realize that he had to have his mother sign an affidavit of death for his father to get his father off the title so that he could neatly and cleanly take away his mother's title. So that's kind of contradictory, and I think it contradicts his claim that he didn't understand what he was doing. The restraining order after hearing can mirror everything that you asked for in the temporary restraining order, but you can add two things. You can ask for damages at the time of the restraining order. I don't think a judge is going to give you title or any large damages. I think you're going to have to pursue a separate probate code section 850 petition, as Costa explained previously. You can also ask for attorney's fees for the prevailing party. Now, later on, I'm going to talk to you about there's different standards of care as to different burdens of proof as to whether or not you're seeking a restraining order based on physical abuse or neglect or financial abuse. So to get a TRO, you don't have to give notice. It can be done ex parte. And service of the TRO prior to the restraining order hearing only requires 5 days. If you cannot get the restrained party served, you can apply and get a continuance and a reissuance of the restraining order. Now, the duration of the TRO can be 21 to 25 days. But during COVID, there's a California rule of court that allows the court to issue the TRO for up to 90 days. A restraining order after hearing can be issued for 3 years. A judge might think exercise his or her discretion and issue the order for 1 year. It can be up to 5 years. And before the restraining order expires, you can apply to have it reissued, and you can ask for various timeframes. Now, when you're drafting a complaint for damages, Costa talked about how you can use probate code section 850 to obtain the jurisdiction of the probate court, but you can include other causes of action such as breach of fiduciary duty, rescission, reformation, declaratory relief, revocation of a will or a trust. The format that's required is you need to identify the parties, why the court has jurisdiction, why this county has venue. It's unique in probate cases. You need to list the names of the parties and the relationship to the petitioner and their addresses, and if there's been any requests for special notice. Under Welfare and Institution Code section 15657.01, you can ask the court to issue a prejudgment writ of attachment to freeze the perpetrator's assets. Jill talked about that with the St. Mary's student perpetrator. A lot of times in the elder abuse cases, as Jill was mentioning, the perpetrators have either a mental health issue, a drug issue, or both. A lot of these cases, you're not going to need a prejudgment writ of attachment because the perpetrator doesn't work. They don't have any assets that you can find, but it's an important tool to have in case you have a case where the perpetrator actually has some assets or income. You can also ask the court to deem that the perpetrator, if it's a son or a daughter or someone who would normally be named in the victim's estate planning, to have predeceased the elder. And that request can be made under probate code section 259. In some cases where you don't have large damages, but the damages are significant to the elder, you can refer the elder to small claims court. You can prepare the paperwork. You can go with the elder as a support person, but you're not allowed to talk in the case. You can also consider calling the IRS and asking for a whistleblower reward. The IRS can give a reward of up to 30% if the perpetrator fails to declare as income the property taken from the elder. To me, this is a very interesting tool to have, and there's a presumption under probate code section 21380 of fraud or undue influence if the perpetrator is the drafter of the transfer document, is a fiduciary, such as an attorney, a trustee, a conservator. Third, if the person is a care custodian for a dependent adult, is a son or a daughter, is related, is cohabitating with, is an employee or a member of a law firm. And what's important about that is it creates the presumption of fraud or undue influence, and then it shifts the burden of proof to the transferee to prove by clear and convincing evidence, a higher standard, that the transfer of the gift was not the result of fraud or undue influence. And anyone who drafts a document or is related to the drafter, there's a conclusive presumption of undue influence or fraud under Probate Code Section 21380C. Now, the last thing that I want to talk about is the attorney's fees and costs. There's different burdens of proof. When you're talking about physical elder abuse or neglect, the burden of proof is by clear and convincing evidence. And that's Welfare and Institution Code Section 15657. So you can get reasonable attorney's fees, they're mandatory, and you can get costs. But for financial elder abuse, there's a lower burden of proof. It's by the preponderance of evidence, and the site on that is Welfare and Institution Code Section 15675.5. And in addition, you can recover costs as well. And the costs that you can also recover are the cost of a conservator to assist with the financial elder abuse litigation, whether it's the restraining order or to recover damages. And as I mentioned earlier, sometimes the elder can become unable to express his or her ideas, or you have to worry about their testimony being inconsistent. So it might be more appropriate to get a temporary conservator or a conservator appointed as quickly as possible if you need a TRO or a restraining order. Importantly, in Woods versus Santa Monica Escrow Company, it says that attorney's fees aren't reciprocal to the defendant if the defendant prevails in the elder abuse litigation. But in Bates versus Presbyterian Interhospitals, Inc., it talks about, well, the attorney's fees aren't reciprocal, but costs are. And the court made it very clear that experts aren't part of the cost unless the expert's appointed by the court. So that's pretty much an overview of the tools that you can use to protect an elder or dependent who's been the victim of elder abuse. I haven't been asked to talk about this, but one other tool that you want to have is either know how to do an unlawful detainer action, or have an attorney that you can refer things to that will assist you. Because oftentimes you have to remove, you cannot, even with a restraining order or a TRO, protect an elder. You just cannot. You have to remove them from their home, and then you have to evict the perpetrator, because the perpetrator not only is detrimental to the elder person, but detrimental to the home, is committing waste because they're mentally ill, they have substance abuse issues. So that's another tool that you need to consider. Thank you.
All right.
Lots
Whoa.
of great information.
Absolutely.
All right, we can get,
yep.
You want to get going on the question?
Yeah, I started off, Samantha.
All right, sounds good. I think someone early on at the beginning asked if there was a good resource or a book regarding elder abuse. So let me find that. Is there a good handbook on financial elder abuse litigation?
I can answer that. I like the action guide by the CEB. And also CEB on law is a good resource. Those are two of the ones that I like. The CEB has a lot of resources in regards to elder law and elder abuse.
Carolyn, do you have any practice guides or anything that you like to use?
I like the CEB.
And Joe, you probably have the penal code for you.
Yes.
All right, our next question is, do you use the undue influence concept since it's not a form of abuse, filing a request for a restraining order?
I can
Carolyn,
answer that.
Costa.
So undue influence is a form of abuse. It's something that can be used in elder abuse restraining orders as well. It's a more of a nuanced situation. I would rarely go strictly with undue influence, though. I would bring in some type of actual harm that is provable, such as financial harm to the elder.
I agree
And I
with
know-
Costa. I think it comes into play when there's been an actual taking that's harmed. Like you explained, like where there's 4, 5, 6 children, but one son or one daughter has taken the home, title to the home, and so you would describe it as undue influence.
And Jill, you had wrote a little bit in the chat about criminal protective orders. Do you want to talk about those at all and maybe how they work in your world?
Just basically, I heard Carolyn mention something about being limited in ability to get a kick-out order. And so it's a really nice luxury that, remember how I told you that I don't even do anything. My clerk has all the identifying information from the police reports that we already putting in our case management system to index people, the defendant and the victim alike, plus other witnesses, which are going to be the minor children, other people in the home. And it literally spits it out in the packet. And we literally check, my clerk does it because they're roasted. Stay away, get out of the house, don't come here, and temporary custody orders. And even when we settle a case, I have to, if I don't check a box that says that my order can be trumped by family court, it can't. Criminal courts trump family courts over custody matters. So most of my people do not have family law involved in their lives, but when they do, it is a rare day where it has to be like a felony child abuse or like a homicide, like an elder neglect where someone died, where I will say, as the criminal lawyer, knowing what I know from a 12-page police reports, I am going to say I'm trumping a family court's order. I obviously try not to do that. That is going to be a much deeper dive into the welfare of these children. So I don't do that, but I can. So it's to kind of highlight how the government has the service that's so cost effective, basically free, and so routine.
All right. Doug, do you want to say something?
Well, I was gonna say, Jill, you have some follow-up questions, given that you are the one area that we don't practice. So, shocker. So here's the question that I think actually rolls over into a civil kind of aspect as well. So does the DA take up cases against banks that facilitate ongoing financial elder abuse by refusing to freeze accounts when agent under a power of attorney presents the appropriate doctor's letters diagnosing elders' dementia?
Okay, so the short answer is no, unless we have a violation of the law. Is there a court order saying this asset is frozen and the bank saying not feeling it, not doing it? Then you call the police and you say, I have a court order and this bank won't do it. If you can get the agency to comprehend it, if it's not too complex, if it's straightforward, like these are the assets, this is the order, I want it frozen, and they're not freezing it, then yeah. And what you have going for you with police agencies is they know a lot about asset forfeiture in relation to narcotics investigations. So tell the police officer, go call a narcotics buddy, and they know how to those assets while we sort it out. Maybe it's a viable action, maybe it's not. In the meantime, you've accomplished your objective, right? Maybe I don't file charges, but in the meantime, you got what you wanted, where the police criminally use the executive branch of the government. We shut that down, we sort it out. Obviously, this has to be a good faith reason, but if you have a proper order or a judicial order and the bank's just not doing it, that's a crime. Probably not going anywhere, but that definitely call the police in that situation.
So you answered the follow-up question, which was technically in connection with the question above. Technically, the bank is, quote, assisting the abuser. So can't the bank be sued for financial elder abuse to recoup the elder's losses? And I think you kind of answered that, which is it's a long shot, or nothing.
Well, sue is civil. We don't sue.
Well, okay. So
so yeah.
Then because I've dealt with this issue directly, and I quite frankly hate banks because they make up their own damn rules. And so so what you're saying is if I go in, ex parte, whatever, get an order freezing an account, and I go to the banks and I say, hey, bank manager, give this to your legal department, you need to freeze this account immediately. And they come back and say, oh, well, we're not accepting this order for whatever reason. As long as, I can then call the police and say, I have this very simple order. It says, bank account ABCD123. They're refusing to freeze it.
Yes,
Is that simple?
I would say if it's a court order, it's an executive act, and you would rely on the executive branch of your government to serve that order for you. I wouldn't be surprised if government doesn't like novel things. I would say you have a 50-50 shot of having a beat officer knowing what to do with that, but that doesn't prevent you from trying anyway, and we will get them there.
Awesome. So then for you civil speakers, Carolyn and Costa, in connection with the bank question above, would the bank be considered assisting the abuser if if they're not following, or freezing the accounts, etc.?
I've sued Mechanics Bank twice for negligence.
Hopefully, no Mechanics Banks members are here on this presentation, but if they are, you better watch out for Carolyn Cain. Continue.
Well, the negligence theory, because they're violating a statute, which is that there's guidelines for what they have to do, or negligence per se, they have their own policies. But with mine, it was theft from a Cutma account. And it was really funny because later I bought my daughter a car and I automatically got assigned this loan through Mechanics Bank. So I was wondering if they were going to lose my payments, but they didn't. They treated me just fine.
Hey, Carolyn, just curious, in your litigation with the banks, how litigious were the banks? Because I've had experience with another bank and they really just lay on the litigation, and it's so cost prohibitive that we sometimes have to bow out earlier rather than pursue the whole case. What is your experience?
I think it depends on which law firm you're dealing with, because I often in partition actions, I sue lenders because they're on title. I have to sue them, right? I have to sue all the lien holders. But with Mechanics Bank, the two times in all of those, it just really depends on the attorney. I think it's just like any attorney in this county. Some attorneys you can work with, some attorneys you don't ever want to work with again. And so banks, but if it's a good cause of action, you go after it.
Costa, do you have any comment on that?
Yeah, I was just going to say that very similar to what you were saying, Samantha, is that banks are tough to deal with, and that yes, you can sue, and they are mandated reporters as well for elder abuse, but it's tough to find their service agent for process, and then when they get their lawyers, it's a team of lawyers, and it's the nightmare that you've talked about.
Glad I'm not the only one. All right, so a next question comes, does this mean an attorney can't draft an estate documents for family members like parents if they would be a beneficiary? I'm not doing my parents' estate plan.
I can answer that. A child can do the estate plan. There is a prohibited a statute under, I believe it's 21-380. My brain is a little questionable at this time of the evening, but prohibited people are usually not relatives of that degree, like children. So a child could draft, but it is questionable if that child is now disinheriting all of their siblings. That would be a problem. And then you're talking about, why would that child want to put themselves in that precarious position unless it was an equal split situation.
And to that end, I can say I have drafted my parents' trust.
Of
But
course
it
you
was,
have.
yeah, shocker. But it's split equally. You know, if there was any, you know, red flags or whatever, I'd say, I love you folks, but
And
No,
knowing Doug, that is an inequitable result for his sibling, but
you know, touche.
I agree with Costa. Well, Costa's an only child, so he could draft his parents' will and trust. And I didn't get my Christmas cookies last year, Costa, so I have to mention that. But I think in some families you wouldn't ever want to draft your will or trust. You take mom and dad to someone else.
All right, so we'll move on to the next question. It says, if the alleged perpetrator is the trustee or an attorney in fact, can you ask the court in your EA 100 to remove him or her? If you have to deal with a family conflict, children accusing each other of abusing mom, can you ask for a mandatory settlement conference? Any other request if the restraining order TRO war between family members?
I don't think you can ask for removal of a trustee in a elder abuse restraining order. I would think you would need to apply in the probate court. The elder abuse restraining orders really go with the civil restraining orders. I mean, there's a different application process. I suppose you could apply simultaneously in the probate court, but to suspend a trustee, I mean, you have to show proof of harm. When I applied for those, I was always given a stern warning: don't do this often. You know, don't come in here often asking for the suspension of a trustee, but you can ask for it. And then
Doug, you want to take the next?
asking for a settlement conference, that would be like down the road.
And I think in restraining order courts, at least in Contra Costa for now, they do like us to try and mediate before the cases anyway, but it's always with the volunteer mediator and not with the judge itself. And I think they're having some of those on Zoom with mediators as well for breakout sessions, but I haven't per se seen a settlement conference for one. Is that your experience as well, Costa, Carolyn?
yeah, I mean, in regards to the temporary restraining orders, generally they do promote mediation and offer that. We have a very good bar, a very good court system that promotes informal resolution. And I think it allows both sides to save face. The reality is these are usually families that are involved. So anytime you can have families shake hands and walk away from a situation, it is better, you know, relatively speaking, of course, than going all the way and having one person win and one person lose.
But I agree with what Costa just said, but when there's violence, the last thing I want to do is be in a room alone with my client with a violent perpetrator without a bailiff. Don't want it to happen.
All
Doug,
right.
you want to take the next one?
Sure. So if an assisted living or an institution has a TRO against a certain person and try to isolate a client from other visitors because they may act as the alleged perpetrator's agents, can the facility be sued for elder abuse or isolation for that matter? I'm just gonna use this as an example because Costa's here. So I have I have a restraining order against Costa from visiting my dad. But I know that Costa's friends with Samantha and that he might use Samantha to go visit my dad and do whatever. The care facility is hip to this because I've told them, and they keep Samantha away from my dad as well. Are they, can they be sued for, you know, isolation, elder abuse, etc.?
I mean, I'll just jump in and say, can they? Sure. I mean, that's me being the lawyer. Anyone can be sued. Will they, being the facility, lose? That'll be a difficult one because they are reasonably likely relying on what they have and making a judgment call. And I think that most judges are going to err on the side of protecting an elder or dependent adult and having the matter resolved in court versus coming down on the person like a ton of bricks in a situation like that, at least in my experience.
All right, we got about a few minutes left, so I wanted to get these last two questions. Okay. There are cases where the perpetrator influences the elder to appear and oppose a elder abuse restraining order sought by a family member or attorney in fact. Do you have any advice or tips for demonstrating to the judge at the initial hearing the elder may lack capacity or is somehow being directed to oppose by the perpetrator? I.e., elder says, I don't want a restraining order because I love my grandson, aka the perpetrator, and he takes care of me. I'm doing everything on my own free will. Or is this usually obvious to a judge given the background circumstances such as sudden changes in estate planning documents, etc.?
I think you should consider that before you file. You may need a temporary conservator because some people, when you interview them, they present as very firm in their belief and their conviction, and or they could just be having a good day. So you also have to interview their family members or their support people that how is she doing today? Is this how she always presents? Because you do have to worry about the elder, that if the perpetrator has access to the elder, they don't want the money to stop. They don't want, they're usually people that don't work. They're just parasites, and they just don't want it to stop. And so they wiggle they wiggle their way back into the person's life, and you have to deal with that. And so I think you really have to consider, is this person a strong enough witness to be able to testify? If not, maybe you could, if they have capacity, but they're not a strong in their conviction, maybe you can bring in a power of attorney with specific authority, and that person can seek and as an alternative to conservatorship. I think you have to, or you can do a guardian ad litem for the incompetent person. There's a number of tools that you can do to get away from that weak witness.
Well, and I've experienced I just asked the judge, go ahead and voir this individual. There's a question of capacity, and we've raised that in this, elder abuse restraining order, whatever. Can I voir dire? Can I question the witness right now on, capacity? Sometimes that's good enough because you start asking some questions that they're able to answer it, and then when you switch it up, well, who's the president? What's the day? They start tripping up. So.
But if
I would just,
sorry.
Sorry to interrupt. I would just say it's an imperfect science. I mean, it's just very difficult. The more information, the more details, the more data you have, the better. I've had cases, I'm sure many lawyers have had cases where, we may initially be really gung-ho, and then, the more information we get, we're not gung-ho anymore, or the opposite. So I think that is very important as well.
We got one last question here, and then Anne is gonna yell at me. So if there would be an inequitable result, but there is a good reason, how do you differentiate that with undue influence / elder abuse?
I think the common example is the caregiver. One child was being the caregiver for the parent. Costa, I'm sure.
Yeah, I was going to say what Sam said. I mean, it's almost natural if you are the child who is taking care of the parent while the other children are doing their own thing, that, the parents are likely going to treat that child who's staying home, doing all those things better. So it's a delicate situation, but yeah, I think like Sam said.
Okay, Anne is going to yell at me if I extend this 1 second longer.
Thank you, everybody. And,
all right,
and speakers, you will get speaker certificates. I saw a couple of you asking that. You will get speaker certificates. So everyone, thank you very much, everybody. And I'm going to turn the recording off.